Then in terms of, how do they find out how much the property is worth? There's a broker price opinion. Is that how they're finding out?
The BPOs are broker price opinions. Those go to the lenders, and the lenders get those, and they have it. If an owner or a second TD holder wants to find out, they could just have to probably get comparable market analysis or something like that.
So let's say that in that situation I gave earlier, if there was equity in the property, perhaps a second loan holder may want to go and move forward on a foreclosure.
Correct. If there's equity in the lend, they would go and start their own sale. They are, as you said, they would have to cure the first, and then they would start their own sale. Same time frames, 3 months, 21 days.
Okay. Deeds in lieu of foreclosure, is that done very often at all?
Very rare. A deed in lieu is where the owner gives a deed to the lender and simply says, here's the property, take it back. And the lender would take it back. However, lenders don't want to take it back, because if they take it back, none of the junior liens are wiped off, and so they're very reticent to take anything back.
Right, because in the example we gave before, all those liens would stay with the property?
If the first TD holder took a deed in lieu of foreclosure, the second and everything else would stay on the property.
Okay. What about with the FHA and the VA? In terms of foreclosures, does that change at all if it's a VA loan?
No, they still have to go through the same foreclosure process.
Okay. What about the notice of default with a VA loan or CalVet loan?
Same situation.
Okay. What about in terms of the refinance? Once you're in a, sometimes they could refinance, but if you already have a notice of default and you're behind on your payments, that's probably going to be
very difficult. A notice of default will just take your FICO and just take it up high. So it's if you're going to try to refinance, do it before any notice of default.
The FICO score will go down. Rather.
Very much.
Right. Okay. And then, in terms of speaking with the lenders and telling them what's going on. So you're speaking to their collection department or their loss mitigation department or customer service? Who are the
first, before there's any notice of default filed, and you'd be probably talking to the loan service people.
Right.
If you decide to sell it and there's no value in the property, then you go to the loss mitigation department. Okay. If it goes back to trustee sale, then you go to the REO department. So they got all these different departments with, with acronyms.
All right. Now that we are going to do a show with you on short sales, but let's say they are behind on their payments and they think, wow, we'd like to sell this home. We realize it might be short, come up short. The loans total more than the value of the home.
Correct.
Now that period, it can take weeks or months as well.
Correct. And you have to communicate with the lenders so the 3 months don't run out and you'd be trying to sell it, and the legal department goes ahead and forecloses it.
Right. So if one was to realize that they are in trouble financially and they need to unload this property, the property they live in, need to sell, they should start the process of a short sale sooner rather than later.
Very fast. Very as fast as they can.
Okay. Now I believe you mentioned if that was the case, you want to again speak with the lenders, perhaps send them a bank statement and your bank statements and your paycheck stubs and fill out the application. And
well, in a short sale, it's a very complicated situation because every lender has their own different applications. And it'd be very difficult. I don't hear very few people where the owner, it's because to do this you already have to have a buyer. You have to have a buyer before you start all this. So you have probably dealing with a real estate agent. And the real estate agent then will prepare the package to give to the lender, which will include all the information about status of assets.
So every bank has a little bit different program or application for a short sale. In other words, the requirement is that the occupants don't have cash resources available to move forward with.
Yes, if they have assets, then it's very difficult to get a sale because if they have a lot of assets, the lender's going to say, why don't you take some out of the IRA and pay this? So
right. So it's an application, just like an application for a loan.
Even more complicated because now you're not only checking the credit of the buyer, you got to check the credit and assets of the seller, and you got to get a loan committee to agree. You not only have the seller involved, now you got this loan committee.
Okay, then also the occupant of the home that's in trouble needs to write a hardship letter.
That would be, the hardship letter's got to go. That's the real requirement to be given to the lender. Why did you get in this position?
Right, so you don't want 3 pages, and you don't want to say, I don't want to dip into my CD or IRA.
Right.
In 1 page.
One-page,
Stick to the facts.
succinct, pithy letter, yes.
Okay, and then another thing to slow this process down is the foreclosure process, is the bankruptcy.
Well, bankruptcy would slow it down. It would give the person time, and the bankruptcy court then would have to rule. But the lender would very quickly try to go and get a release from the stay. And the lender would show that there is no equity in the property, and so the judge doesn't have to protect the creditors, so they would go ahead quickly and release it.
Okay, so let's put that in layman's terms. A lot of times, occupants that are in trouble, they go to an attorney, and perhaps they get legal advice that if they file bankruptcy, because there's probably problems elsewhere, that could slow down the foreclosure process.
Yes.
And they could live there for free for a while.
For a while, probably.
Okay.
But then you got the bankruptcy filing on your record.
Right.
That might even be worse than a foreclosure.
Right. And then the lender perhaps will come up and say, listen, there's no equity in the property anyway.
And then ask the judge to let them go ahead with their foreclosure.
I see.
When the bankruptcy is filed, it stops the clock running. Let's say 2.5 months have gone, it stops the clock, bankruptcy is released, then they start running the time again.
Because there was the stay of execution, for lack of a better term.
Yes,
right?
execution.
And then the release from the stay.
Correct.
All right. And then there's also new laws that pass, right? The new federal law?
They have speeded up bankruptcy for the judges. And so in the bankruptcy of the past where they lingered on, they're pretty fast right now.
Okay. And then Chapter 20.
Well, that's just a joke I used in class.
Okay.
There's a Chapter 13 that is a plan to get out of bankruptcy.
Plus a Chapter 7.
Chapter 7 is liquidation, so I always say tell the lender you're going to do a 20, which means you'll do both of them.
Right, yes, I set that joke up for you.
Thank you.
Yeah. Okay, and then the eviction process.
Well, what happens, this is after the trustee sale. After the trustee sale, in almost all cases, the owner is still sitting in the property.
Now, the trustee sale is on the county courthouse
or
steps.
Steps,
just like it was 200 years ago.
Correct.
Right.
It's an auction.
Right.
Nobody shows up, lender owns the property.
Got it.
And that's what happens in the vast majority of the cases. The lender owns the property, they take it back. Now the owner is still in the property. So what happens then in today's market, most of the time, the real estate agent who's got the listing goes out to the property, and the first question he asks is, when are you going to be out?
Right. Right.
That's the big question.
Okay, let's speak about that, because on the county courthouse there's an auction at say 12 noon or 3 o'clock in the afternoon, and then they're reading off the addresses, and then there's certain people gathering around, investors.
Correct.
And if no one bids on that property, boom, it goes back to the ownership of the lender.
And it's called REO, real estate owned.
Real estate owned, REO.
That's the acronym.
Also bank owned is another term.
Bank owned, yes.
Now that said, so those banks typically have a preferred realtor that they will use in a particular zip code.
Yes.
And then that listing will be assigned to that realtor.
Correct.
So then the realtor goes and knocks on the door?
Yes.
Okay.
And his question always, if you talk to anybody who's had this happen, the realtor is instructed to say, when will you be out? And then they negotiate, because the person is still sitting in there. They can't get them out without an eviction to get a writ of possession, which would be very timely. So in most cases, there's something called cash for keys, and the real estate agent's authorized to offer the person some money to move.
Right. Okay, so let's review that process. So the foreclosure, after, by the way, on the courthouse steps, no one bids on the property, goes back to the bank.
Correct.
Does it happen that day or a week later?
Well, it's very quick. I mean, the trustee goes, finds out, and quickly gives the trustee's deed back to the lender, and they get the property pretty quickly.
Okay. And then how is the occupant notified that it's been foreclosed? They get a notice on
Well, they know the trustee's sale. They've been told with a notice of default. They've been told with a notice of the sale, so they know the sale's that day.
So they know that day it's all over.
It's all over.
Okay, and then the realtor pulls up in his Cadillac the next day?
Well, realtors maybe today wouldn't be a Cadillac.
Or not a Cadillac today, but today.
But they come up with their Cadillac, and they are required then to help the bank, and they help the bank in getting the property ready for resale, but the biggest problem is the person still sitting there.